Hello, I'm Bill Traynor, Dean of Georgetown Law, and it's my privilege to welcome our audience members from India, in the United States, and from around the world. Last fall, Georgetown Law launched a highly successful new series on comparative constitutional law, featuring conversations between Indian Supreme Court and High Court justices and leading legal scholars at Georgetown. And we're delighted today to have the opportunity to continue our comparative conversations on the pressing matter of access to medicines in the COVID-19 era. The program today is a result of a collaboration between the Society for Democratic Rights in New Delhi and Georgetown Law's O'Neill Institute for National and Global Health Law, our Center for Asian Law, and our Institute for Technology Law and Policy. And I would also particularly like to thank our alum, Prathiba Makhija, without whom these programs would never have happened. So I'm so grateful for her vision and her commitment to these conversations. Today's program is an extraordinary opportunity to compare the approaches of the world's two largest democracies in facilitating access to the COVID-19 vaccine globally. For this conversation today, we are incredibly honored to host Delhi High Court Justice Prathiba M. Singh, alongside Georgetown professors Matthew M. Kavanagh and Madhavi Sunder. Justice Singh, who I had the privilege of meeting on my trip to India shortly before the pandemic. Justice Singh is a sitting judge of the Delhi High Court. Prior to her elevation, she headed a significant litigation practice specializing in intellectual property rights. She was pivotal in spearheading the viewpoint of Indian pharma companies in the Novartis litigation in India, which is now a leading judicial precedent worldwide. The Novartis judgment of the Indian Supreme Court in 2013 was a groundbreaking judgment, balancing public interest rights with the intellectual property rights of pharmaceutical companies. Justice Singh's valuable insights have been published in leading Indian dailies, including the Times of India and the Hindu, and we are so proud to host her in today's events. Thank you, and it's such a privilege to see you here, Justice Singh. We will also be hearing from Matthew Kavanagh. Professor Kavanagh is a visiting professor at Georgetown Law. He's an assistant professor in the Department of International Health, and he's director of the Global Health Policy and Politics Initiatives at the O'Neill Institute. Professor Kavanagh's research and policy work has long focused on access to medicines and the intersection of law and politics in global infectious disease. He's presented his research before UN bodies, the US Congress, and the US Trade Representative. So welcome, Professor Kavanagh. And finally, Dean Madhavi Sunder is a professor of law and associate dean for graduate and international programs at Georgetown Law. She is a leading scholar of intellectual property and law and culture. Her book, From Goods to a Good Life, Intellectual Property and Global Justice, was published by Yale University Press in 2012. Professor Sunder has written extensively on human rights and access to medicine. So it should be an extraordinary conversation. We are so privileged to be able to host it. And I will now turn the program over to Dean Sunder. Dean Sunder?
Thanks so much, Dean Traynor, for supporting these incredibly important comparative conversations that, as the Dean mentioned, we began last semester and are so happy to be continuing now. And thank you to the Society for Democratic Rights for being such a great partner to Georgetown Law and a wonderful intellectual collaborator. So the Dean has set up the questions of this hour. How have the world's two largest democracies approached patents and public health? And why are both the US and India so important with respect to global access to medicines? What are the implications of the varied approaches of these two countries in particular for resolving our current public health crisis and for the equitable distribution of COVID-19 vaccines? These are incredibly timely questions, and we're so fortunate to have two leading authorities with us today at Georgetown Law to discuss them. So we're going to start with our conversation now with the panelists. Justice Singh, Welcome. Professor Cavanaugh, welcome. Justice Singh, I want to start with you. As the Dean mentioned, you were the principal architect of a leading judicial precedent worldwide now on an important case that was decided by the Indian Supreme Court in 2013, the case of Novartis versus Union of India. In that litigation, you represented Cipla, the Indian pharmaceutical company, which disputed the patentability and evergreening of a cancer-inhibiting drug, Gleevec, claimed by the international pharmaceutical giant Novartis. Justice Singh, can you just first share your personal experience of involvement in that historical litigation with us?
A very good morning and good evening to all of you. Dean Trainer, thank you for the very kind introduction. I'm very thankful to Georgetown Law and Ms. Vibha Makhija, the Senior Counsel from India, for having me here. And Dean Sundar, I'm taking the liberty of calling you Madhuri today. Thank you so much. It would be unfair for me to claim to be the architect of the Novartis case, because I think it was a team effort of so many lawyers, so many participants, so many litigants, and both Novartis and all the companies who were litigating, and of course, primarily the Supreme Court judges who did such a wonderful job of writing that judgment. You wanted me to share some anecdotes from the judgment and the experience as a whole. I can say only one thing, that Novartis, the case of Novartis was landmark for all of us, because not just because of the fact that it was a case relating to one particular drug, but because it was laying down such an important proposition of law for India and for the world on the balance between patent law and patients and treatments and healthcare, etc. So I just think that the manner in which the Novartis decision spanned out, as we'll be discussing the merits of it today, was that it brought to fore a debate which was only in the courtroom, which I say went into the drawing room. I had women whom I met at social events who spoke about patent law, which I think happened only because of the Novartis judgment. And so the manner in which patents are perceived completely changed with Novartis. And this was one of the first cases where the inventor himself was sitting in court, Professor Zimmerman. He came to court when the hearing took place. And I remember the emotion on both sides was so high. One of the counsels representing Cipla actually called TRIPS as a treaty of coercion for India. And the judges were really shocked at that kind of an expression. The drug itself was something which all parties agreed, was a path-breaking drug. It was called the magic bullet for treatment of cancer. There was no question about the merit of the drug, because the drug itself was used and is in use currently as well. But the only question was whether after the initial drug was in public domain, because there was no product patent in India in 1993, whether the second form of the beta form of the salt could be patented or not. So we'll be discussing the merits and demerits of that again. But there are some interesting anecdotes from the judgment itself, from the case, which is not in the record anywhere, which I think are highlights of this judgment. I met Justice Alam once after the pronouncement happened. And I remember he told me that he typed this manually on a manual typewriter, considering the importance of the judgment. He didn't want to even dictate the judgment to a stenographer. So that was one interesting anecdote. And the second important learning from this judgment is we don't need specialized judges to decide patent cases. Both of these judges who came, one from Patna High Court, one from Bombay High Court, they may have never done even one patent case in their entire life. And they had to decide this case. And they wrote a brilliantly worded judgment without any errors on patent law. And it stands the test of time even today, so many years down the line. It's almost 8-9 years down the line. And nobody's pointed out any major error in patent law which has been written in that judgment. So it proves the point that judges without specialized experience can decide patent cases. And this debate of having specialized and non-specialized judges, I think can be, it can be a learning from this decision. And one interesting thing in this judgment was the manner in which how almost as a woman, I felt very proud that almost all the assisting counsels on both sides were girls. And the only boy who was in our team actually broke his arm lifting bags of the Novartis case. And the judge remarked, "Oh my God, you broke your arm in this matter." So it had lots of good memories for all of us. And I would end my answer there on anecdotal experiences of Novartis.
Wow, thank you so much. That's great. And I just want to point out that you have sent us many amazing women students who are focusing on public health to the O'Neill Center at Georgetown and through our LLM program. So thank you. Well, I want to follow up because for our audience members who might not be as familiar with the litigation, this case was being watched not just for its importance for ensuring equitable access to this Gleevec medication, this silver bullet magical medicine that you have pointed out throughout India, but India has been long known as the pharmacy to the developing world. And so the whole world was watching what the Indian Supreme Court would do in this case, because it would have implications for the ability of Indian generic drug companies like Cipla to be able to continue to manufacture high quality, affordable drugs for the developing world. So I wanted to hear from you, Justice Singh, how did that global import of this decision, how did that affect the way you and your team approached this case?
I must say that when we started in our office, the preparation for this case, I almost had sleepless nights because this was not a case which just represented one client and a victory or a defeat in that one case. It was a case which was going to lay down the law for the future, post TRIPS in India, how a provision of law which was enacted only on the floor of Parliament would be interpreted and whether it would stand the test of time, as we would say. It was not just about whether Cipla would win or lose or Novartis would win or lose. At least from my perspective, I had at least 25 lawyers working under me at that time. And each one of those lawyers was involved in this case, despite the fact that we were a very big litigating firm at that time. And for those 15 days when we were it was our turn to argue, you cannot imagine the number of hours we must have put in. I don't think anyone in my team slept more than 5 or 6 hours in a day during that time. It was a huge responsibility. It was a responsibility not just for patent law that we were shouldering, but we did feel that, India was to show the way to the world, because by then Section 3D had been replicated in at least 2 to 3 countries, in other countries. And the provision was going to be tested. And as you will notice when you read the judgment of the Supreme Court, we had to do a lot of research. We went to the Parliament Library, the Indian Law Institute, the internet. Of course, we had the internet at that time, but I don't think as much information as it's available today was available that time. The debates from Parliament, we actually obtained from the Parliamentary Library in India. And this was a case where across party lines, political parties debated the provision. The bill had a completely different version. And when after 3 days, the bill became an act, the provision was completely different. So not just lawyers worked in the Supreme Court, parliamentarians worked to enact this law at that time for 3 days. So that was the significance of this provision. It was a provision which was enacted, as they say, on the floor of the House, which is very, very rare. And we all understood the real meaning of what the word legislative intent means in this particular case. I'm sure parliamentarians researched on patent law and debated on the floor and then enacted this law. So it was a very big responsibility. And one thing that reminds me is all the teams of clients who used to come to the Supreme Court, at least the team which we were representing, we used to, in the lunch break, sit in a small conference room, and I would actually carry lunch for them during this hearing. So that was the kind of commitment that we all had for this case.
Thank you so much. That was wonderful. So, I mean, you're pointing out that this was really the effort first of the legislature back in 2005 in enacting Section 3D, the anti-evergreening provision of the Indian patent law, to say we recognize this important global role that Indian generic companies play in enabling access to affordable medicines worldwide, and particularly in the developing world. And so they basically said you can get a patent if you create something really if you're offering a breakthrough technology, but if it's a mere tweak or a modification, then under Section 3D, we consider that to be an attempt at evergreening, just forever keeping your minor modifications, using those to keep your technology under patent. And the Indian legislature first said, in India, we're not going to allow that. We want to have this balance between being able to promote innovation, but also access to generic drugs on the other side of those patents. And then your case obviously was so important. Justice Singh, I just want to say how in awe I personally was as a professor of intellectual property in the Novartis decision. It's truly an epic decision. It's 112 pages long. The Indian Supreme Court mentions health 33 times. And it's really just so powerful in how holistic it is at looking at the history of what is the purpose of patent law in India, and also, though, understanding the impacts of the patent law on access to medicines for the people of India and around the world. How did you feel in reading that decision? Were you surprised by its humanitarian focus?
I was planning to say this when in the constitutional question and context. I think there's a fundamental difference in the manner in which India's constitution is framed. Right to health is a part of our fundamental right, whereas development of a scientific temper is a part of our fundamental duty. But development of scientific temper comes with it humanism in the Constitution of India. So scientific temper, which is so closely connected to innovation, is immediately linked with humanism in India. And considering the long history that India has had with patent law, in the 50s and the 60s, I remember, Professor Sundar, in one of your articles, you referred to the Iyengar Committee report. I think the thinking in Indian patent law, when we enacted the 1970 Act itself, when our Prime Minister spoke at the General Assembly, I remember she said it was one of the landmark speeches given by a head of state involving patents. And she said, the best thing would be when all innovative drugs are available to each and every patient across the world. So I think India has always been, a different player in patent law. While we recognize the need for innovation, we also recognize the need for making innovations available to the people who need it. And I remember, in one of our pharmaceutical drug patent cases, I was cross-examining a cancer expert from UK. And he was appearing on behalf of the multinational. And this is actually something which I will never forget in my life. It was a cancer drug. And after my cross-examination running over 2 days, at the end, I asked him, Dr. So-and-so, you are an oncology doctor, and you prescribe medicines for cancer patients every day. I asked you a final question. Given a choice between an innovator's drug and the generic drug, if the quality is the same, what would you prescribe to the patient? And his answer, without a flinching of an eyelid, was, I will prescribe the generic drug. And he was, mind you, he was a witness for the innovator in the cross-examination. And so I feel that the research community and the doctor and the medical community wants all drugs to reach the masses and the patients It's up to the innovator companies and the pharmaceutical companies as to how they will make it more accessible. It's always a balance, how to recoup investment and how to make it accessible. I think this debate will continue, and I think we will all be debating this and making better tools, creating better efficiencies to make sure that there is access to medicines.
Thank you so much. I want to now turn to Professor Kavanagh and bring you into continuing this same line of conversation, because Professor Kavanagh, I want to ask two things to you. One, just what's the role that that India as a legal system around patents and public health, and obviously as the a primary creator and distributor of generic drugs, what role does India play in this larger global set of debates around access to medicines, and in particular, the Novartis decision? What has been its impact? Could you tell us a little bit more about that from your perspective?
No, and thanks for having me, and Justice, thanks for joining us. We are so thrilled to have you here.
Thank you, Professor Kavanagh. I've heard a lot about you, actually.
And you. We are, India plays an incredibly important role globally when it comes to public health. The reality of India as the pharmacy of the world is true and is increasingly true. It's worth even noting that if I walk right down, I'm in Washington, D.C., if I walk right down my street, I can go to the CVS. And in that CVS, I can pull all sorts of Indian-made generic drugs off the shelf. And that's because of the law, right? That is because of the legal infrastructure that's been created. So it's not just the 26 million people around the world who have access to HIV treatment. It's also those of us who need access to more affordable drugs. That's been really central. And I think key to that, as you've been describing, is this question of Section 3D, right? And I think it's really key to understand, and one of the things that India has shown to the world is that within TRIPS, countries still have space, right? There's still law and policy space within TRIPS to have a patent system that actually works for public health, that works for various development levels, but also works broadly. And I think there's huge implications, and I'm sure we'll get into this, for the United States about this, right? But as we think about Section 3D, and it's a core, at its core, right? It's about what's the definition of an invention. And TRIPS lets countries decide what is their definition of an invention, right? India says, look, just discovering a new form of an old invention isn't a new invention, right? The really important part for those of us who work a lot on public health is to say one of the ways we'll know that in the world is that we'll see it in efficacy. One of the things in public health, if there's a brand new drug and it does not improve outcomes, in public health, we say that that's not an advance. And if we have a brand new drug that doesn't improve outcomes for patients and it's more expensive, that's bad in public health, right? We'd consider that to be a step backwards. And yet increasingly, that's what we're seeing, driven by a patent system in many countries that rewards the filing of patents over the kind of core innovation pieces. And so one of the things I think that India has really brought to the conversation is a question around quality. Right? What does it look like to have high quality patents, to have a high quality IP system that actually drives toward what we're going toward? And they've pioneered a number of different pieces. Section 3D is one of the key pieces that I think the world could learn a lot from.
Yeah. Do you mind talking to us a little bit more about some of the other innovations that have come out of India that you think could be quite impactful for other countries, including the US?
To me, one of the most important pieces is pre-grant opposition, right? So if the goal of an IP system and a patent system is to not just have lots and lots of patents, but instead to have high quality patents that are doing the things that we want, then we want to have something like a 3D that incentivizes pieces of kind of real innovation. But we also want to engage the public and engage people. One of the things that our work really shows, that those of us that have been involved in global public health for a long time, is that IP is huge stakes for people's health. It's really actually quite important. It's not some other system out there in the world that's divorced from well-being, that's divorced from how good your computer is going to work. But certainly on public health, how well you're going to be able to get access to medicines is key. So one key innovation has been this patent opposition system, right? The pre-grant opposition system. The Indian Patent Act provides for both pre-grant and post-grant opposition. Any person can, in writing, lodge an opposition to the controller against the grant of a patent. In the US, we don't have a pre-grant opposition system. And this has had huge implications. One example that I often talk about is the story of Tenofovir, which is, it's a key HIV drug. It's used around the world. Millions of people have access to this drug. And the reason millions of people have access to it is because of the Indian patent system, right? The fact that folks were able to go in, and it was people living with HIV in India. And really interestingly, in this instance, it was also people living with HIV in Brazil who jointly filed a set of oppositions against the granting of a patent on tenofovir, right? And the grounds were, we've looked at the patent, we've looked at the drug is not innovative. It was actually discovered in the 1980s. And if it's been discovered in the 1980s, then where's the innovation? And so said the originator company, the innovation is that we put it together with this salt. And very smart activists and lawyers got together, looked at all of this, and they said, look, the salt is known, the drug is known, how is it not obvious to combine the drug and the salt, right? And in the United States, we would just kind of automatically grant a patent like that. But in India, they were able to go forward and actually say, we, the people living with HIV, are helping the system, we're looking at things, and we are seeing that this doesn't meet Section 3D. And that patent wasn't granted. The result of that patent not being granted is that 26 million people around the world have access to HIV treatment. Almost all of them are on a tenofovir-containing regimen right now. And so that had huge implications worldwide because of that. And I think, that idea of giving people a way to engage in the patent system improves the quality of patents. This isn't bad IP, this is great IP, right? And what it's hopefully doing is it's actually incentivizing real discovery.
Yeah, I want to ask Justice Singh, did the pre-grant opposition, did that tool play a role in Novartis?
We always had the pre-grant opposition in India. It was whether in the 2005 post-TRIPS regime or even in the previous regime. I don't think there's anything surprising in a pre-grant opposition, because we all know that trademark practitioners as well, we use pre-grant opposition as a tool to oppose any non-grant of a trademark. And that's the automatic thing even in a patent. You do a pre-grant opposition. But what happened in the 2005 amendments was that we allowed even post-grant oppositions, which was not there. So earlier we had pre-grant and we had revocation. But when we added a third limb in between, like a post-grant, there was a lot of apprehension expressed from the international community, and rightly so, as to whether grant of patents would be held up forever. But I must say that here I would think that the patent bar in India, the IP bar, and the judges in general have been very, very good in streamlining the system. They have said that pre-grant, if it's granted, the journey ends there. You can't take it further. The only option then is to go to a post-grant. You can't have parallel proceedings running between pre-grant, post-grant, and revocation. You have to have one running at any point of time. And therefore, initially, there was some confusion as to how the system would operate. But right now, I think the system has worked very well. All three are living, happily between each other. And insofar as the Novartis decision was concerned, yes, when the 98 application was filed for the beta-crystalline form of imatinib mesylate, there were 5 pre-grant oppositions which were filed. And that led to the assistant controller rejecting the patent, and then the IPAB modifying it, but still rejecting it, and then the thing reached the Supreme Court. So pre-grant oppositions, I think, are absolutely essential for any system, because before grant of a patent, it requires to be tested at least once. And the most important thing is there is judicial decision which now says that pre-grant opposition is in aid of the examination. It supports the examination of the patent itself. So it's in aid of the examination process. It is not considered kind of adversarial to the examination. It's not like the examination takes place, it's about to be granted, then you file a pre-grant. No. So pre-grant happens along with the examination, and they both happen together. If claims need to be reduced, amended, shortened, cut off, all that happens, and the patent is granted once and for all through the pre-grant. I think it's a very robust mechanism, and I think pre-grant is very essential in a patent system.
Thank you. So both of you, I think, have really highlighted the use of these tools like Section 3D against evergreening patents and the pre and post grant opposition tools to really go to the core of what a patent is about, and that is promoting breakthrough innovation, something new that actually helps the world. As Matt said in the public health context, does it actually improve people's health and have a therapeutic effect? But I want to, I think both of you are well aware that the same spring 2013, the US had its own important case that went to the Supreme Court involving patents and public health. And that was the case of Myriad Genetics. Myriad Genetics, a private company, had claimed to own the patents in two human genes, BRCA1 and BRCA2. And mutations in these particular genes suggested a high likelihood of developing breast or ovarian cancer. And actually, in both the Indian Supreme Court case and the US Supreme Court cases decided that same spring of 2013, the Supreme Court's invalidated the patents. But the approaches could not have been more different. And, in contrast to the epic, holistic, humanitarian-focused decision of the Indian Supreme Court, the US Supreme Court's decision was an efficient 18 pages, and it never mentions the word health once. And I want to throw it over to you, Professor Kavanagh. I mean, does this suggest that the US and India espouse competing visions of patents? And what's the importance of these, if they do, to what extent are these two visions driving the way we think about access to medicines today? And soon we'll be talking about what the implications of those visions might be in terms of access to COVID-19 vaccines in particular.
Yeah, I think we are very much seeing two different kind of visions, and they're poles on a spectrum that don't differ that much, right? It's really important to understand both Indian and U.S. Patent law are fully World Trade Organization compliant, right? Both countries have aligned their laws with WTO agreements, meet all of those pieces. And we know that in part because despite all of the saber rattling from various countries, there haven't been WTO disputes filed, right? There's lots of, oh no, India's not following the rules, et cetera, said in public. But when it comes to dispute mechanisms, they're not being filed. So that tells us in international law and in international politics that actually everybody does accept that India's patent law is strongly WTO compliant. So then what's different, right? And I think the U.S. has a ton to learn from India in that way of how do you do patents and how do you do an IP system that actually kind of brings in questions of public health. In the U.S., it's far easier to get a patent and there's really few ways to challenge it, right? And so some of the pieces that I hear Justice Singh saying, well, of course we have that, right? Just don't exist in a U.S. context. And the result of that, right, there's a really great study done by colleagues at IMAC that shows, look, that the top selling drugs in the United States have on average 125 patent applications filed on them, 71 of which is granted per drug on average, right? These are multiple overlapping patent thickets that result in evergreening. On average, these drugs have 38 years of patent protection, right? Twice as much as the imagined 20 years that we're actually talking about. And that has not led to more innovation. And in fact, we're really worried, right? Those of us in public health, we're worried about less innovation, right? And the pace of innovation and the cost of innovation going up without seeing the kind of same impact. We're also seeing, right, that not only less innovation and less invention, but we're actually seeing that the majority of patents are covering science now that's already been done, right? And the result of that is just increasing prices, right? So in the last few years in the United States, only one of the top 12 drugs in the United States has actually decreased in price. And that just tells us something, right? We should see over time that, of course, products become more affordable as time goes by. It's a kind of principle of economics, but the monopoly system is preventing that from happening. And it's not necessarily driving better innovation. To me, India's got some very important pieces, right? A strong patent system. The Indian Patent Office is actually, very widely respected and studied around the world, right? But it also considers, as the justice was saying, right, access and public health and health as a human right. And that says we need to think about what does it mean to make patents higher quality, right? To make sure that what's being awarded for a patent is really novel, not obvious, and really useful. And if that's the case, then that's what patents are supposed to be. And I think the US actually could learn a lot, especially in a context in which we are facing soaring drug prices. We need not be in quite the same way we are. And I don't think we're kind of, the argument that we're inherently getting the innovation from that holds much water at this point.
Thank you. I want to turn our attention now to COVID-19 and access to vaccines. Professor Kavanagh, this week in the United States, President Biden announced that he expects every American adult to be vaccinated by the end of May. This is great news at home, but of course, it's also enabled us to look outward and to ask, what is going to be the situation with respect to access around the world, and in particularly in the world's poorer countries. As we also know, there have been philanthropic endeavors by Bill Gates and working with the WHO. And through those, we can expect perhaps some 2 billion doses of vaccines to be delivered to the developing world. But that's just going to be a drop in the bucket compared to really getting access, providing vaccines to all those who need it around the world. Experts say that unless something changes, many low-income countries won't receive herd immunity until 2023 or 2024. So I want to ask you, what are the key obstacles right now to ensuring equitable access to COVID-19 vaccines globally?
Thanks. And I'm glad for us to turn to this key question going forward, because it really is, I think, the test of global solidarity and of the world's system of producing and distributing, science, right? We are talking a lot these days about pandemic preparedness, but pandemic preparedness completely fails if people don't have access. It is wonderful that we're talking at this point about getting everybody in the United States access to these really cutting edge vaccines. The fact that they've been developed in under a year is remarkable. This is a very good sign. And in Malawi, where a bunch of my colleagues are, right, the hospitals have been overwhelmed over the last month with the new South African variant. They're not able to face up to it. And there's zero access to the vaccine right now. So while, we're talking about how many people can we fit into various civic centers, Malawi's got no access. In South Africa, they're still talking about a tiny portion, right? The idea is that the time period that President Biden wants to get everybody in the United States vaccinated, most countries reliant on the COVAX facility are only going to be able to vaccinate about 3% on average, maybe 20% by the year end. And for those of us that look at pandemics, that is a crisis, right? Because you don't get anywhere near herd immunity at 3% or 20%. But what's really important to understand is that this is about scarcity, right? We've spent a lot of time focused on how we're going to distribute it, who's going to get the doses, right? But we're not focused on why is there scarcity. And the reality is that the scarcity is fake, right? It's false. It's created by not sharing know-how. Could be that factories around the world are making these vaccines, right? We could fix this, right? And we've been here before. What's really, to me, remarkable is that we've been here before in the terms of that, like, there were millions of folks waiting for HIV drugs for a decade. 6 million people died waiting for HIV drugs in East and Southern Africa between the time the drugs were discovered and they finally rolled out. So we knew this was coming, and it's happening again. So to me, the core question we've got to answer is, why aren't we sharing the knowledge that's been pioneered, right? And then if we are up for sharing the knowledge, which I think we should be, then how do we do that, right? And there are a ton of examples of how we might go about this. Many of them come from HIV, right? Where you can, for example, pool licenses, right? Where we put the IP into a central pool. We know, right? And this is, I kind of laugh, right? But that we know there has not been a time when high-income country-based companies have served the interest of low and middle income countries well. It just hasn't happened. There's a variety of reasons for that. Some folks would say, that's greed. Some folks would just say, look, there are multiple different market strategies, right? But the bottom line is we just know empirically that that's not happened well. So let's pool that IP. Let's have a focus on, makers and producers who are really good at serving low and middle income country markets. Let's have them serve those markets, right? And that's what worked in HIV. And then the second is really tech transfer, right? How do we get the vaccines? It's really important. I'm describing HIV, and HIV is a good parallel, but making HIV drugs is not the same as making vaccines, right? It's far easier to reverse engineer an HIV drug that's a small molecule than it is a vaccine. We need to think about how do we get the tech transfer over there. But we've got models of that too, right? I mean, we can think about, dolutegravir came to the market, which is a key cutting edge HIV drug. It came to the market in 2014, and within months, the company Mylan and Cipla and a couple others were all making the drug in India. And they were making it because ViiV, the company that owned the license, not just said you can use our patents, but also said, here's how you make it, right? We're not going to serve the South African market. We're not going to serve the Malawian market. Here, you guys go ahead and make that. That's what we need right now, right? We need to think about kind of freeing the knowledge, not just freeing the doses.
I think you both mentioned, the rapid speed, relatively speaking, by which we were able to get this number of vaccines. But I want to ask you, how important is the fact that the US government provided the lion's share of the funding for many of the new COVID-19 vaccines, including the Moderna vaccine? Indeed, many people are calling this NIH's vaccine, or even the people's vaccine. And I guess I wanted to hear from you more. What role can that public-private partnership play in promoting some of these things you've talked about, like tech transfer or patent pools, Professor Kavanagh?
Yeah, no, it's a great point, right? I mean, and I often, as we've looked at this, right, as far as I can tell, right, and this is from all the public literature, about $2.7 billion was invested, for example, in the Moderna drug, right? $2.7 billion. Almost all of that, 99.9%, came from the United States government, from a variety of different sources, right? There was $1 million that didn't come from the United States, and that came from Dolly Parton, right? I'm pretty sure that Dolly Parton would agree, and I tweeted this the other day, right? I'm pretty sure she'd be up for us sharing the know-how that she supported with folks around the world, and the United States should be in that business too, right? We're not going to end the pandemic until we're able to end it every place. We know that that's true. So if everybody in the United States is vaccinated, but the global economy is still shut down because much of the world is in the middle of a pandemic, that does not serve US interests. And so we need to switch away from an America first kind of policy much more rapidly. But what's interesting is, because the United States government funded so much of this, and it's not just the Moderna vaccine, it's a variety of the vaccines, put in billions of dollars, that also gives the US legal and political leverage. We can use the Bayh-Dole Act to actually march in on the technologies that we've paid for, to say, look, you're not using it over here. We need to use it in this way. We need to actually make this available to a variety of folks. We've got the Defense Production Act that would allow the US government to expand production of various pieces. And that would get us into the kind of tech transfer that we need to be talking about, right? The kind of, there's a whole world right now of a sub-industry that does tech transfer every day, right? If you make widgets over here and you want to make them in your factory over there, you can hire a company that will figure out how to do that and will make it happen. The same thing can and should happen, and does regularly in pharmaceuticals, right? Moderna, for example, or Pfizer, sorry, bought a factory in Germany and they stood up production in 3 months, right? 3 months, they went from it being an empty factory that had nothing into having a factory that was working. That's all about the kind of things that we could do if we were to leverage the kind of funding that's available, right? So the United States should put in funding. The United States should, support others to put in funding and work with partners around the world. But the key missing piece is we need the know-how. We need that technology, and it needs to be transferred because it's in our interest. The fact that the United States taxpayer funded it actually does give legal leverage immediately for actions.
Thank you. I want to turn to the questions from our audience, and we have so many experts in the audience itself. I want to share one from Charles Clift. He's a board member of the Medicines Patent Pool. And so Mr. Clift is asking you both to address the issue of a possible TRIPS waiver. So right now, India is leading the way along with South Africa, asking the World Trade Organization to waive patent rights with respect to COVID-19 vaccines. And the goal would be to allow for more production of these vaccines around the world to rapidly vaccinate the world. The WTO may be deciding on this waiver as early as next week, and so Mr. Clift is asking, would this proposed waiver by India and South Africa make a material difference? Do we need this waiver? Is it going to really matter? Will it make a difference to the availability and accessibility of vaccines, therapeutics, and diagnostics for COVID-19? Do either of you guys want to take that one?
Okay. since it's about India, I'll just make a very small comment about access and in the COVID-19 pandemic. I really think that as an Indian, I'm very proud about the role that India has played in this pandemic. And whether it was exporting tons and tons of hydrochloroquine immediately when the pandemic broke out, or exporting vaccines now, scaling up its operations, we are being vaccinated across the country, stage-wise, phase-wise. Almost all the frontline health workers have been vaccinated. Now we have moved on to the adults and to people with comorbidities. I think, and the vaccine is so reasonable in India. It's less than 30 cents. So it's just amazing how India as a country has responded to this pandemic. And I think whether it's through a TRIPS waiver, which is the executive's job right now thinking of the executive that there should be a TRIPS waiver. But there's definitely one thing that needs to be there, taking a cue from what Professor Kavanagh just said. I wrote a piece last year, just immediately after the outbreak of the pandemic. You used the word, Madhvi, PPP, public-private partnership. I actually called it the pandemic patent pool. We should have a pandemic patent pool without, if the patent community today doesn't respond positively and behaves in a selfish manner, there will come a day that the world and the humanity will start hating patents. We don't want that. They will not want that kind of a position. So we need to make sure that humanity is saved, it is surviving, and we all get back to normalcy quickly. And the best way to do it is to share the innovative resources that are available to make sure that access happens almost automatically and simultaneously across the world. And one or two models that really come to my mind, when I was practicing as a lawyer sometime in the year 2013-14, I recall one licensing policy of a famous innovator company, which gave out licenses to about 14 companies in India to manufacture the drug. And those 14 companies could export to about 100 countries in the world. It was a patented drug. And the innovator company earned in two ways. It earned royalties from all those 14 companies. And then I recall the CEO of that company telling me that we have learned so much because of the new methods of manufacture that the Indian generic companies have made out in that particular licensing. So they reverse own the IP in the processes developed by the generic companies. So I think there's a lot of mutual learning that can take place. And whether it's through waiver or whatever tool it's going to be, a patent pool is what we should definitely look at to make immediate access almost on an overnight basis. And I don't think there should be any debate or even a hesitation on this, because the international community should love patents. The people of the world need to love patents. And if they need to love patents, they need to be out of this pandemic.
Thank you, Professor Kavanagh. And I also did want to mention that the U.S. is opposing the waiver, at least, at the last, kind of look at where they stood. So what do you think about the waiver? And do you have any prediction about where the WTO is going to go on this next week?
Yeah, and I mean, I think, as the Justice is saying, I think it is just incredibly important to kind of say that there's two things. When the pandemic hit, the World Health Organization said, and the president of Costa Rica said, we need a patent pool. Let's stand one up. And they did under something called CTAP. But do you know how many pharmaceutical companies have gotten into it? Zero. This is, to me, remarkable, but this is a failure of law. So let's use our legal tools. And this is where the law comes in a really important way, right? Which is, this is a regulatory issue, et cetera. The TRIPS waiver, I think, to the question coming in, is an incredibly important tool, because what it does is, right, it says we need a suspension, the option to suspend the TRIPS agreement, to suspend patents and a variety of other exclusivities during this pandemic, right? We want to allow countries to not enforce, not apply, not implement pharmaceutical corporation patents during the pandemic. And the reason why we need this is because countries need to be able to use their legal tools immediately to collaborate right now on figuring out how to make these drugs, make the tests, make the vaccines. And all three of them matter, right? It's interesting just to note, right, as an aside, South Africa has struggled to get reagents to do diagnostic testing, right? There's been a whole bunch of 3D printing of ventilator valves and people have been sued over it, right? So we're not just talking about vaccines, we're talking about the range of COVID technologies. The point is to say we're in the middle of a declared public health emergency. The WHO has declared it to be true. So shouldn't we suspend patents for the moment, right? The waiver would be temporary, et cetera, and that would allow countries to go about their business in figuring out how to get this production up. And it matters because the current structures, when HIV was ravaging much of the world, there was the Doha Declaration. And the Doha Declaration of the World Trade Organization, countries came together and the consensus built to say, look, countries can use a variety of flexibilities to suspend enforcement of IP when you need to for public health. But what the Doha Declaration didn't foresee is the number of different barriers that would then be put up. Right? So if you want to, for example, make a drug in X country and send it to Y country, in theory, you can do that. But do you know you need to issue a compulsory license in X country, a compulsory license in Y country? You have to do it on the exact technology. You have to fill out all the forms. You have to do all of those pieces. Meanwhile, there are millions of people dying. We're in the middle of a pandemic, right? So this cumbersome process that's been created. Plus, it's just worth noting that every time countries do use the compulsory licensing strategies that are allowed under Doha, the United States government puts them on the special 301 watch list, threatening sanctions. So we need a kind of global, this is both a legal and a political question of shouldn't there be a WTO agreement that says during this pandemic, it's time to suspend TRIPS as it relates temporarily to COVID technologies. At this point, 2/3 of member countries have actually come forward and agreed, right? So South Africa and India proposed it. At first, it wasn't clear where it was going to go. The African Union just came on board fully. Now 2/3 of WTO members are on the record supporting it. In theory, that should be enough, but unfortunately, because of the way the World Trade Organization works, it's a consensus-driven organization. And the United States and Europe are blocking consensus, which is using a variety of parliamentary tricks, but also just kind of broad political tricks to mean that until they unblock it, it's going to stay stuck. And so I am hopeful that maybe the Biden administration will realize that this actually isn't in the US interests, right? They've talked a lot about kind of re-engaging with the world, being part of the world again, getting it away from an America First strategy. I think it is increasingly untenable for the G7 countries, the wealthy countries, to be sitting around vaccinating all their populations and watching everyone else die. And so I'm hopeful at least that maybe there will be some backing away. I think there's some cracks, but I think unfortunately next week, I'm worried that it won't have happened soon enough, but we can hope.
Thank you. I'm going to take one more question from our audience for both of you. And this is a question from Rahul Bajaj. He's a law clerk at the Supreme Court of India. And Mr. Bajaj is asking, in the adjudication of patent law disputes, how far does the right to health play a role, directly or indirectly? In what way can we deepen the linkage between patent law and the right to health? Do you want to start, Justice Singh?
Yes. It is a very oft-asked question, because in every patent litigation, when we go up and argue in a pharmaceutical case or any of the medical diagnostics or those kind of cases, the right to health is at the back of everyone's mind, whether it affects the final decision making or not. But having said that, I want to say that while the Novartis decision has made India well known in the area of global health, the decisions which have followed in India have all kind of struck the right balance. I recall one specific case, which again involved Novartis and Cipla, where it was a respiratory drug, and the defendant, Cipla, argued that we should be allowed to manufacture it in India because Novartis is not manufacturing it in India enough to cater to all the patients. So the High Court said, no, so long as the patent is valid, you cannot manufacture it. And if sufficient quantities are not being made available, please apply for a compulsory license and get a license. So whenever a judge is hit with a case of right to health, the judge first sees the strength of the patent first. If it's only kind of borderline strength, only then the right to health will prevail over the patent itself. However, if the patent is very strong, then other tools would have to be used as per the statute. But I would agree with Professor Kavanagh to the extent that in the pandemic, I'm not sure how well the compulsory licensing mechanism will work, because there are several preconditions which would be required to be satisfied. India has a very long provision dealing with compulsory licensing, but you will be surprised to know, despite all the bad name that India has got on compulsory licensing, we've just given one compulsory license since in the last 25 years. I don't think we've given more. And I think countries like Canada, US and European region have all given much more compulsory licensing than India has done. So I think right to health is very important, as the querist is saying, but it's always patents and right to health together and not just one over the other.
And I'll just say quickly to come in, I think this is also true at the international level, right? So, the UN Secretary General a few years ago put together a panel called the High-Level Panel on Access to Medicines, because at the global level, the UN is based on a kind of key set of agreements. One of them is an international human rights system that includes the right to health. The other is the international trading system. And what he recognized at the time is that the two are increasingly clashing, right? We have a classic conflict of laws. You can't both have a right to a medicine under all of the kind of, whether it's the domestic litigation structures that have shown what a right to health looks like in a variety of jurisdictions around the world, or whether it's the international jurisprudential thinking around the right to health. Neither of those matches with a monopoly that's unbreakable on the patent when, on a drug, when it's either not available or not affordable for people. And so we have this, and that high-level panel came together and made a whole bunch of recommendations. It upset lots of people for all the right reasons, I think. And it really is starting to have to face this question of this clash of ideas. My hope is that maybe in the coming years, if we do see a shift back towards a rights-based system writ large, we might see that kind of take hold in a new way that could be really important.
Wonderful. I just want to thank you both. I think we all learned a tremendous amount. And I think one of the ideas that I was perhaps most struck by is the need for patents, absolutely. But in order for patents to stay committed to their ultimate purpose, which is to serve the public interest, and that might be to promote health or to promote the kind of innovation that really matters to people and improves lives, that really what you're both talking about, whether it's in the context of the right to health or not, is just about making patents work better for people. So thank you both. We are now going to invite Kashish and Neha to give some concluding remarks. So Kashish is a proud graduate of Georgetown Law Center, one of our 2019 LLM graduates, and he is also a co-founder with the wonderful another alum, Vibha Datta Makija. They are both co-founders of the Society for Democratic Rights. We love to see Georgetown Law's commitment to lawyers as leaders and serving the public good, moving in the directions that you are all leading it into in India and around the world. So thank you. Kashish, please take it away.
Thank you, Madhuri. March last year, the entire humanity was living in extreme uncertainty. In almost less than a year, several effective vaccines were in mass production. And today, with just an year into the pandemic, we hosted a judge, a lawyer, and a political scientist for a comparative discussion on access to the COVID-19 vaccine. This in itself is phenomenal. Until recently, law was the only tool to fight the pandemic. This pandemic has given humanity an opportunity to re-examine how law interacts with health, and I'm so glad we were able to kick off this conversation today. I would like to thank Justice Prathiba Singh for graciously agreeing to be our guest today. We are extremely privileged to have her with us. Thank you, Professors Madhuri Sundar and Matthew Kavanagh, for your invaluable inputs and for making this conversation extremely engaging. Dean Trainer, thank you for being a true leader and an inspiration to all of us. I'd like to thank the entire team at Georgetown University and the O'Neill Institute for National and Global Health Law for being an amazing co-host, and a special mention to Live Law, our media partners in India. We look forward to more such events. And finally, I thank our team at the Society for Democratic Rights for making this event a great success, and especially Vibhat Datta Makhija for all his support and for being the backbone of this organization. I thank the entire audience for joining in today, and particularly the Indian audience who has tuned in this Friday evening. I hope everyone gets vaccinated at the earliest possible opportunity, because nobody wins until everyone wins. Thank you and take care.